I'd like to introduce my colleague and dear friend, Robert Birkin, who will introduce our next speaker.
Thank you very much, Lynn. I want to extend a personal and institutional thank you to the Tulsa Law Review for assembling such a wonderful group of scholars to honor and discuss the work of Richard Epstein. And I particularly, at this moment, want to thank Professor Robert Ellickson for accepting the Tulsa Law Review's offer to join us in Tulsa today. Professor Ellickson has been the Walter E. Meyer Professor of Property and Urban Law at Yale Law School since 1988. He has published numerous articles on topics such as land use, land tenure, homelessness, and the role of informal norms. I believe he first became acquainted with Richard Epstein approximately 40 years ago when they began their teaching career, or had their early days of their teaching career at the law school at the University of Southern California. Professor Ellickson's books include The Household, 2008, recently published, Order Without Law, awarded the Order of the Quaff Triennial Book Award in 1996, and Land Use Controls, Cases and Materials, co-authored with Professor Vicki Bean, as well as Perspectives on Property Law, co-edited with Carol Rose and Bruce Ackerman. Please extend a very warm welcome to Professor Robert Ellickson. Thank you so much for joining us.
I'll start with thanks to Dean Janet Levitt, who actually was one of my students. The older I get, the more often I say that, I find. And also to the Tulsa Law Review. I think that they have put together an exceptional group today. My remarks are designed actually to press Richard on his views on the Kelo case, because he likes to mix it up, so that's where I'll move. But I thought I would start with some accolades. I wasn't able to be here yesterday, so I don't know to what extent Richard was glorified or over-glorified, Richard, possibly, by speakers yesterday. I do go back 40 years with Richard, and one of his characteristics, even today, he's relatively boyish. Those of us not in our group of those collecting Social Security, I mean this is a compliment. Many of us who are collecting Social Security cannot be so described. But I think Richard can be, and so you can imagine him even 40 years ago, he might have been more so. We had, Leanne raised the issue of luck, an interesting question. We were at USC, and was that a matter of skill on our part to associate ourselves with this institution, or a matter of luck? I think Richard probably agrees with me that we were extremely fortunate, let's say, use that word, to be at that school at that time, because the median age when I joined the faculty in 1970 was 33 years old. And that's an extraordinary figure. I don't think any law school in the United States is nearly that young. And youth brought a lot of energy and creativity and perhaps brashness and so forth, but it was a very, very stimulating place, and I think put a stamp on my career, and I think probably let me just say that the man today is recognizable from the man 40 years ago. At that time, since we're in the Sweet 16 period, it's appropriate to say that Richard at that time could jump high enough to touch the rim of the basketball hoop with the bottom of his palm. And I probably has lost a little bit in the jump in the ensuing years, but he was, among other things, he was the star of the faculty basketball team, whatever that was worth. But the great energy that he has, another characteristic which is truly extraordinary and reflected by this conference, is the breadth of interests he has across the field of law, is matched perhaps only by Richard Posner. There are others who perhaps are in the league, but it's less than the fingers on one hand. And so Richard truly is extraordinary in that way. He also, I think, was then and is now very courageous in that he is not afraid to take a view on a subject that he knows will be controversial, and there aren't that many, and that's, of course, very stimulating for everyone else, and I commend him for that. A last feature that I want to point out is, because you might not expect it from his writings, is Richard I regard as a distinctly communal person. He is devoted has been devoted to the institutions to which he has been associated. And you might think of him as a rugged individualist who would not behave himself in that manner, but that is not the Richard that I know. Okay, on to the substance of my remarks. As my title indicates, they will center around eventually the most reviled, popularly reviled decision of the U.S. Supreme Court in the last generation, perhaps, the Kelo decision, which held that the city of New London, Connecticut could condemn as part of an economic development project the house of a homeowner, Ms. Kelo, and that this did not violate the public use clause of the Fifth Amendment. And so I'll get back to Kelo a little bit. But to set up my comments on Richard's views on Kelo, because Richard has been the leading critic of the Kelo result, let me identify four strands of conservative thought. We're in Oklahoma, which is a redder state than most, so that conceivably this is more relevant. These strands are more relevant here than they would be back in Connecticut, where I live. I will associate Richard with two of these strands, but one of my points is why are the other two strands not at all present in his thinking, and it's not that he's not aware of them. So I think he's thought about these matters. So I'm interested in how he would respond to them. Sometimes these strands are congruent in how they would react to something like the Kelo case. I think with Kelo they are not congruent, and some strands of conservatism would be very anti-Kelo result. Other strands, like the one that I hold, support the Kelo result. So let me identify the four strands. One is libertarianism, let's call it. Which is, I've actually visited the Kelo house before it was torn down, as it now has been. And Ms. Kelo had a flag outside which said, "Don't tread on me," one of these ancient flags from the American Revolution and whatever, and that captures the view of libertarianism. Leave people alone, the state should leave people alone, other individuals should leave them alone, sort of a system of negative liberty. In his own writing, Richard has, in many places, identified himself at the outset when I knew him at USC, as a natural rights libertarian, that this was his view, and then you have to decide what these natural rights are, and but that was his view. In the Takings book, which I think is his most famous book, published in 1985, he announced that he was no longer a natural rights libertarian, or he had morphed from that position into a utilitarian, to use his own phrase. And the morphing was easy, he claimed, because these actually positions, ideologies were so congruent that they almost always came to the same result. So it wasn't hard to make this particular move, that if you were a believer in private property or freedom of contract, that was right both on libertarian grounds and on utilitarian grounds. There is, since Richard has been, ideas have been discussed elsewhere, there is a literature about whether you can make this a move and regard these things as congruent. Interesting example is slavery, for example. Suppose we could show that slavery is actually better for the non-slaves than it is worse for the slaves themselves, that it adds to the size of the pie. Are we in favor of slavery? And that would put these two theories in tension. Now, actually, I've looked up Richard's views on slavery, and he is anti-slavery, and he has actually said he says there's actually a moral imperative that you own yourself, but he also gives some utilitarian reasons, which I think are there, by the way, that people not be slaves. But in the end, I'm not sure he's an entire utilitarian, and he. At any rate, he is, I think, not changed himself. Richard is a person who doesn't change from article to article, but he drifts a little bit. I still think of him as, thinking of himself as largely a utilitarian, by and large, an approach that I tend to agree with, dealing with small duration, not on slavery, but on issues of adverse possession law or defenses in torts cases, or the Kelo case, for that matter. The utilitarianism is a fine way to think about matters. I regard utilitarianism as a conservative, I group it, perhaps incorrectly, as a conservative theory, because people who are big pie, have their focus on the big pie, tend not to have their focus so much on distributive justice corrective justice, and so forth. And that, if you want to use this word conservative, perhaps put them in the conservative camp. Okay, now here are the dogs that don't bark with Richard. And so my question, since he's aware of these dogs, I want to ask him why they're not barking. And these are questions of structure, I will say. And the last two conservative ideologies that I will identify focus on issues of structure, not on substance, like simple rules. They don't care about these simple rules and whatever. They care about how the simple rules are made. So the first of these two is I will call Burkeanism, after the ideas of Edmund Burke, the great Irish-born statesman from 2 centuries ago, who was quite appalled by the French Revolution and so forth. And Burke is associated with a couple of ideas about the process of lawmaking. One is go slow, be wary of dramatic change. It usually doesn't work out so well, and that was the French Revolution in his own time. He also was quite skeptical of the ability of top-down elites to conceptualize and bring about things, and much more confident about bubbling up of ideas through customs and civil society and so forth. So those are issues of structure and how rules are made, more than about what the rules are. I did a little citation count of Richard's. I think there were 227 articles I found in Westlaw. I may not have picked them all up. I couldn't do this for the books. Richard also has, I don't know how many books by now, over 10 certainly, in the teens probably. But in the articles, there are no citations to Edmund Burke, 0. There are, on the other hand, 67 citations to John Locke and his theories of first possession. So it's not as if Richard is anti-English philosopher at all. Somehow Burke is not in the picture, even though Richard is aware of Burke. Let me just say that there is a revival in Burkean thought. Burke is back big league across a wide spectrum of scholars. My former dean, Anthony Kronman, is one of them. Tom Merrill, one of my colleagues, is another. Cass Sunstein, who recognizes trends and fads in legal scholarship quite well, has jumped on the Burkean bandwagon to some extent. And I think Ernest Young at Duke is probably the most devoted Burke scholar. So it's interesting. Why no interest at all in Burke? Now I'm sympathetic with a lot of this Burkeanism, but let me identify the fourth strand of conservative thought, which I identify more closely, which is what I will call federalism. And since Richard has been one of the star speakers of something called the Federalist Society, you would think that maybe his views would closely adhere to the Federalist Society. But by the way, when I don't think the members of the Federalist Society are particularly Federalist either, so they're more libertarian. But here's my definition of federalism, and briefly about why I find it attractive. I think the better term for it is actually subsidiarity, which is not as well known a term in American circles, but this is the principle that responsibility for handling a task is best decentralized to the least centralized institution capable of handling the task. And sometimes that will be a pretty large institution, because if the goal is national defense, or perhaps dealing with an economic crisis with the monetary and fiscal policy, you're not going to do that at the city level or the state level. So sometimes that will call for national or international action. But in a lot of situations, you can decentralize to the smaller decision makers. And not only that, you can decentralize it out of government to market participants, or to the actors in civil society who create their own rules through norms and families and so forth, which is one of my favored moves, which is to get it out of the legal system altogether, which I think happens much more than we. This principle is pretty widely endorsed in a lot of circles. It is the core, this notion of subsidiarity is the core principle around which the European Union is, in theory, organized. I see it not honored there, but it's because they centralize much too much. But they say that our goal here is subsidiarity, deciding what is decided in Brussels. This principle is, I think, deeply embedded in the American Constitution, which gives limited powers to the federal government and has a 10th Amendment. And also state constitutions, which get a little play in law school, and state statutes provide for something in many states called home rule, which provides real powers in certain areas to units of local government and whatever, and takes it away from states. So we are there's lots of evidence that we are committed to a decentralization. Again, and let me show a difference between this theory and Burkeanism, about which I also have considerable sympathy. Should we overrule Roe against Wade, for example, take a trivial problem, never a matter of national debate? If you're a Burkean, you might agree with the concurring opinion in Casey, which was, I assume everybody knows these cases, which said that maybe Roe was wrong when it's originally decided, but it's become now part of the national fabric. People are relying upon it. So if you're a Burkean, you might just say, let's keep it because things should go slowly. If you're a decentralizer, as I am, and you think that there's no reason to have a national rule on abortion, which is my view, you overrule Roe against Wade, not because it has the wrong views on abortion, which is where most of the debate occurs, but simply that it made the wrong decision about at what level we should be making rules about abortion, and made them on the national level. So that's an example, in my mind, of how these two philosophies would come out differently. I could spend some of my time on why I regard federalism and subsidiary a useful principle. I will pass on that on the theory that at every law school this is a central topic in constitutional law and whatever, and there are, in the opinions about federalism, Justice O'Connor has a nice summary about the advantages having interjurisdictional competition, different outcomes in different places, more participation, more control over politics at the local or decentralized level, and also so lots of reasons to decentralize. So here's my puzzle for Richard, and I'll get to Kilo shortly. He is very well aware of the advantages of federalism, and by my count, he might have a different count, has two major articles on federalism itself, the one in Stanford and the one in Law Contemporary Problems, where he is absolutely on top of all these arguments. So it's not as if Richard is not aware of these kinds of arguments. He's fully aware of that, and he's also fully aware of Edmund Burke. He has heard this name and read him and so forth. But again, and he's sympathetic to federalism in theory. However, in his basic books, like Takings and the book Principles for a Free Society and so forth, there is no discussion of structural issues at all. Federalism does not appear in the index and whatever. So when we get to the talking about substantive issues, all these structural questions kind of drop out. And so that will be my question for him, basically, which is why, in a case like Kilo, why have all these structural questions entirely dropped out, even though he's aware of these structural questions? It's not a matter of ignorance. Okay, very briefly on my views on Kilo to allow to set up the debate. I assume many of you or most of you know the facts of this case. Richard and I are in entire agreement that this was an abuse of the power of eminent domain. This was a very bad project. They should not have taken Ms. Kilo's home. And in my little piece that I'm writing for the Tulsa Law Review, I've actually done some more research on the facts of this case, and I say that more confidently than I would have before. There's a book out by roughly a journalist. It's a pretty good book called Little Pink House that goes through all the details about what happened in New London. Basically, this is very close to some of my core substantive interests. What cities do with their urban areas. Cities undertake these kinds of clearance projects. This one involved 90 acres, not on their own initiative, but because some higher level government has dangled money that they find irresistible to turn down. And without the dangling of that money, they never would have undertaken this project. And that is certainly the case. In the facts of Kilo, the dangler was a governor named John Rowland, who initiated this project basically on his own. He was later imprisoned the same year as Kilo, by the way, from having taken kickbacks from contractors. And in my view, that's one reason that politicians like this project leverage to get goodies, campaign contributions, and other kinds of things. The other great example is urban renewal in the 50s and 60s. I don't know what went on in Tulsa, but the track record of urban renewal in the United States is just dreadful. And it only happened because the federal government provided subsidies that the local governments found they could not turn down. So I think this was a very bad project. The other thing is New London did not need Miss Kilo's house. The main things that they were trying to do, they were basically doing it for the Pfizer Corporation, a very big corporation. The court denied that, but basically, if you read this little pink house, it's clear that they were. But basically, they didn't need for the things they said they needed. They didn't need Miss Kilo's house, and as Richard has pointed out, she had great subjective value, as did other people in those houses. So this was an abuse of government. This is confirmed, by the way, by the history of the project since 2005. The research I tried to do on what's happened in New London is Ms. Kilo has now lost her house. She settled for a large sum of money. And the site is entirely cleared. No new buildings have been started in New London. Entirely vacant. This has been not economic development in New London. This has been economic loss, as a fairly typical story. So this was really a bad project. All right. Who should take care of this abuse? And this is where Richard and I disagree. If the Supreme Court decides that the public use clause prohibits this kind of abuse, we have nationalized the control of abuses in a significant way of eminent domain, and we've also taken it out of the hands of the legislature. As a matter of structure, I am very skeptical about whether either of those moves is a good idea. In fact, I think they're a bad idea, and I applaud the Supreme Court here. Basically, 5-4 decided it was not a public use violation of the public use clause, because what this allows different states and localities to develop their own law to deal with this problem of abuse of eminent domain. In my view, it's hard to imagine an issue which is more localized, that has fewer externalities across state lines than these kinds of property issues. New London is very close to the state of Rhode Island. I think what Connecticut and New London do in this vein has no effect on the state of Rhode Island. Maybe you can contest that and whatever. This is a classic instance where you want law to be made at the state level and the local level. Notice that in our regime, property law, tort law, all of that is basically made at the state level. I think our country has benefited enormously by having interjurisdictional competition and the development of these very basic bodies of law. I just spent my sabbatical in France, and let me tell you, it's not that way in France. It's all decided in Paris, and that's the way it's done in most countries. I'm delighted that we have a different law of adverse possession and eminent domain in different kinds of states. So my view is that is federalism is good. In my view, the aftermath of the Kelo decision shows two things. One, it shows the tremendous influence of the man of the hour, who has done more than anybody in the United States to contribute to the outrage that occurred, in that he made defense of property rights respectable. And as you well know, there's outrage on the left as well as the right. Richard may have some a little bit more effect on the latter group than the former, but maybe not. There was great outrage. And to my delight, because I am a decentralizer, all of this occurred, or virtually all of it occurred at the state and local level, which is exactly what you want to do if you believe in subsidiarity. You want initiatives to be made, ballot measures, legislation. But some of it's symbolic, didn't change a whole lot, but there truly was a big debate. In the state of Connecticut, where I live, the governor turned around on that. Within the city of New London, politics changed to a considerable extent, and there was correction, if you will, from below. I think the Connecticut Supreme Court, which should have dealt with this issue, should have affirmed the trial court decision here, which would have held that Ms. Kilo's house, but not others, but certainly Ms. Kilo's house, could not be taken under these circumstances. And the Connecticut Supreme Court, in my view, made a wrong decision on this, but that's where this case should have been decided. And as if you follow this area of law, you know that some state Supreme Courts, notably ones in Michigan and Ohio, have in fact toughened up their own public use standards. So in my view, if you believe in issues of structure, think that they're important, you're actually just delighted with how the Kelo proposition has played out. So my question for Richard, since he's aware of these structural issues, just to repeat it, is we'll welcome questions from others as well, is that why, since you're aware of these issues, why do they sort of drop to the side when you comment on it? Richard did, as soon as Kelo came down, write an opinion, an op-ed about the case, saying this was a truly horrible decision. But his views on eminent domain, by the way, are very sophisticated, very utilitarian. He would allow, in some cases, like the Mill Acts, which are the famous example used in Clarence Thomas's dissenting opinion, he would allow eminent domain for a private manufacturer in some situations, particularly if there was extra compensation given and so forth. So it's not that he is a knee-jerk in favor of don't tread on me here. He actually has sophisticated utilitarian decisions. But I would, again, why are the structural questions dropping out? Why is Edmund Burke, a man you've heard of, Richard, why is he never cited? So, end of remarks. No, why don't you should be in charge here. Yeah. Actually, those are the ones that we're going to talk about when we start to talk about things that I didn't know. Maybe we're talking about the beliefs. I dropped that. I dropped that out. It was so preposterous it wasn't really worthwhile to try to find. So I mean, that was a surprise. Look, my answer. Never understood Edmund Burke. One of the reasons why I don't cite him, but I do make. And on one was the Federalist custom, negotiation, other avenues of interpretation. So it's not as though these themes don't resonate, but it's happened, of course. When I wrote this down in the INS case, what we found out is that you've got to get an equilibrium situation where customs over again. So a lot of that discussion is when does it work, when do you contact? Brian Simpson's great piece on rapid organized so they don't have to worry about it. Well, I mean, that is, I think, that the serious thing. On the federalism stuff, again, you know, I wrote this thing called the Proper Scope of the Congress House. Articles designed to give me, and this was basically arguing that the Lincoln Bridge federalism that often on the same kind of. I wrote a bunch of pieces on exit right under federalism. I did one with respect to insurance, one with respect to basic. But in all of those cases, essentially, one of the problems that you have is federalism protects people with mobility. Doesn't. So this comes later, and I don't know if you've read this stuff. It's understanding the constitutional stuff. Very strong federal presence. Now, I would describe it, I do not think that the federal government has any power to use it. But to say that you want to keep them out doesn't mind my necessary follow that they don't require kind of a minimalist secretary. I actually argued, I wrote a brief in the Kelo case, and I helped the guys there. I mean, I had real differences with the which is frankly misread by them. The
takes out all the words that matter to make it appear as though they're using rational basis tests in 1905. The other thing is that the way I argue, and the way I would argue is given the look, I don't think you have to go and embrace the test in the grand field. So in the case we have 2 points. One is that the trial judge split the difference between intelligible theory, you can try that. But you stay away from the grand issue and avoid all this chaos. Other than whether you do I said in the brief is horrendous, just ignored again, was that what you do is you wait until they identify you. Connecticut court, they do federal decisions, they always have to keep everything in reserve. They were actually given the egregious nature of the event to take place. So that would be the way in which I would start to think about. So essentially, structural stuff and subsidiarity. I'm now writing a piece called The Optimal Constitution. Is that you can be relatively confident about the structure of private rights that you would like to be dependent on a constitution. Substance, strong property rights, freedom of contract, limited scope of use power, inflicting in-kind compensation, whatever it is. When you're trying to play the structure game, I mean, you can't take the American structure constitution, but the non-American. There it seems to me that you have to be much more eclectic about it. Find that any structure that tries to build in some redundancy, that's the proposition. The imperative case. So I know listening to all this.
No.
Just a little bit closer, and the reason why I federal television is because, like Upward told you, there is a federalism control over the state.
Having not read Slaughterhouse, people keep talking Slaughterhouse to me, but I haven't read it since law school, so my remarks would be incoherent. As I understand, the essence of the theory is that the Privileges and Immunities Clause was a better ground for Bill of Rights or something, and this was rebuffed in Slaughterhouse. So apparently that may be in the news. I mean, the court may be asked and.
Yeah. So it's sort of a positive right, because in the case called Sen, just what he did is he took the language of 440 Coriel, which says you're allowed to go for a state verdict for purposes of
right.
Eliminated the last word, made it into a welfare clause, put a period in the law before done. I mean, this is kind of nobody can defend himself.
Right. Yeah, this is. I could spend the rest of the time here responding to some of these threads. Let me just focus on a couple of them. If Kelo had come out the other way, I think Richard, it's interesting how modest his in opinion he wanted the court to write here, that that maybe if they had a particular plan that they should remand. Then these cases, notice, would come first into the federal courts. And Tom Merrill, my colleague, has done a lot of empirical study on public use cases over the years. And what he found is the federal courts never are sympathetic to plaintiffs in the sample that he studied in these public use cases. But the state courts were. So you go to state court. No, but my view is that you want these cases in the state court. Now, in my view also, the quality of the state judiciary in the United States, in general, I don't want to say anything about Oklahoma, about which I have no knowledge, but it's often not as good, actually, as the quality in the federal courts. But to some extent, that is a function of how you assign responsibilities. If the people of Oklahoma knew that the state courts were the main bulwark here against eminent domain abuse, that might have some effect on how much they paid their justices and how they selected them, and so forth. So my own view in teaching land use, and Richard has, I've enriched him by using his torts book, and he's enriched me by using my land use book, well knows that the federal judges just hate to get land use cases, and these kinds of cases coming in, they will use every trick of abstention and whatever to get these cases out of here. They say, what are they doing? A zoning case from Tulsa? And it happens to be in the Eighth Circuit. So, good. I'm all for it.
It's so bad.
Yeah.
This you will not like.
Yeah.
Turns out that the people
okay, that's one thing. The other thing is, in my typology as conservatism, I did not introduce and have anything fancy to say about social conservatism, and that is, I think, is related in some ways to Burkeanism, in that often there is a major dose of stick with tradition, which includes religious traditions and whatever there. So I think if I were to take that as a subset of one of my four, that's where I would place it. But I think it may have a different.
So I wanted to push you a little bit on another on the interplay between two structural things.
Yeah.
I'm not sure how to legislative versus judicial.
Okay.
So I was curious how, sort of in your perfect world, how that would play out at say the state level. Would it mean that say Michigan?
Yeah, very good. There is a problem, and Richard has identified it, and in a long footnote I'm addressing it because he talked about this, is landowners can't exit, and therefore landowners are particularly vulnerable to exploitation by political majorities because if they are abused, they're just sitting ducks, and the regulations would capitalize negatively in the value of their asset, and this makes for a real threat and whatever, and so now we have often a problem of legislatures picking discriminating against discrete and insular groups and whatever, and I think there is a role for judges and constitutional protection to some extent here. So I think there is a judicial role. On the other hand, in this area, thanks in part to Richard, after Kelo, in fact, many statutes were passed about dealing with levels of compensation and the amount of necessity that has to be shown by the government. And I think, by and large, I do prefer legislative action. By the way, I should tell you, I have what I call the scum theory of politics, which is that, unfortunately, the political sector attracts a subnormal group of people in terms of morals, illustrated by John Rowland, I just mentioned. We're all good people who go into politics, but if you are a scoundrel, politics is actually not a bad career line. So I have no great, I'm not naive about legislatures, but I do have some structural preference for not having judges decide everything before us.
Well, first of all, I just want to say, I think that professor-student relationship is one that's ongoing, and I certainly have work, and in fact, I've used it a lot in my own work on an international level. Thought about bottom-up lawmaking, so I like the analogy there, and written a lot about informal. Actually, I suspect that it would. So I'm very sympathetic to structural ideas, federalism, and I guess I prefer to use aren't you also oversimplifying a bit sort of the options? And so the federal government is intertwined level sufficiently
Right. Okay, that's a moderating, this is interesting. Richard might support this. It's interesting that he and I have known each other a long time, and he's dead right that we often would start on some issue and announce some relevant principles, and they'd be wildly different, and then we would get out to the actual applications and whatever, and they would be surprisingly congruent. I do think in the eminent domain case, you might have an opinion out of the Supreme Court someday saying that it has to be truly outrageous or something like that, and pick up a case of that sort. My own view, as those of you who teach property, is some of the exaction cases might be like that, Nolan and Dolan, is that occasionally what the court will do is what I call a shot across the bow theory of decision making. The United States Supreme Court does not want to spend its time developing arcane rules about subdivision exactions. If what this is, if you're a developer, apply for a permit, you can only get it if you dedicate a beach easement or something like that. But they say there's actually real issues out here, and what we will do is once every generation sort of issue a decision and sort of announce that actually there's some real issues here, that landowners are vulnerable and whatever, but in fact stand back and let the state courts, for example, to be at the front lines of deciding the cases. So I'm sympathetic with that view. I do think that you're absolutely right that all of these governments are interlinked. I do think that one thing we do as law professors is we try to educate people into what they're up to and whatever, and what an appropriate linkage is. And my own view is that cities get involved in all sorts of foolish projects because of state federal inducements, and you can tell a political story about that. And the only solution I see to that is sort of maybe education will help a little bit. I'm not too optimistic about that, but that's one of the reasons we write our long and tedious law review articles. So anyway, it's always a pleasure to see an ex-student do well, Janet. So.
I wonder if you have any thoughts on kind of framework for making trade-offs among could take a superstructure where you're going to have more bad results. There is a federal preemption area.
Yeah, right.
I think we were on a panel once with the Federal Society in the back room was saying, why isn't this called wire? Federal preemption.
Right.
It's really just something of the kind of libertarian
right.
interest to think about regulation. But it's great. Some people, as you say, pick one of those four to sort of champion.
Right.
Why seemingly the most important.
Right. Well, I'm not sure that you can develop an equation here to resolve these kinds of things. I like math, so if I could develop an equation, I would. But I just think it's unfortunate to live in this world with one of the main thing we try to teach our students early on, that there won't be some right answers that you can solve with equations very often here in law school. My own view is that I totally agree with Richard that for a lot of the small scale stuff on the merits, utilitarianism is a pretty useful perspective. And on the other hand, that decentralization, when you can do it, now products liability is an excellent area because Richard and my friend Gary Schwartz, was, as I remember Gary's views, was in favor, thought that products liability, since products are national and whatever, there was actually a pretty good case for federalization there. And that's a subsidiarity kind of thinking. And how, again, I'm not sure you can boil all this down into an equation in a way. But there are, under the principle of subsidiarity, as you know, that I don't know if that was articulated in this conference you went to, but there's a better case for nationalization of products liability than there is of the ordinary automobile accident, I would think.
Your characterization of what's happening that erosion, that's actually what is happening. polarization isn't great. You're getting the same type of public choice problems that you have
Right.
elites and others passing laws. And so what we're finding is a lot of the outrage has been muted through the legal mechanisms that
Right.
that they thought they were erecting to protect them.
Right. Now, your colleague Ellickson follows all these sorts of things, and and much more closely, maybe you have as well, more closely than I have. My sense is a lot of what you say is descriptively true, is that a lot of the so-called, in fact, non-reform. It's all just trying to deal with the anger in an ineffective way. My own view, however, is the politics. It probably, how long this will last, I don't know. Is that the politics of these projects has changed. That, and for both legislators, local legislators, state legislators, whether they appropriate monies, for example, and that certainly was true in the short run in Connecticut. That very much was the case, and whether or not that will play out more in the future. I also think judges who are largely elected, the United States judges who are largely elected, if they want to be reelected and to recognize how unpopular this TLR result was, this may have some effect on how these cases fare in the court. So I think it has to be followed, and Richard and I, one of our great we've shared a strong cynicism about politics, which seems to be fairly current in the room. So, I'm largely there with you, but I do think that sometimes the world changes, thanks in part to the great man.
Thank you.